Lisa from Been There, Got Out. Sorry, we're starting a few minutes late. I have today's guest who has not done an Instagram Live yet, but we love Instagram Live virgins. Her name is Adrienne Woods, and she is a bankruptcy attorney based in Manhattan. And we actually got to meet in real life. And she's super helpful and informative. And I say I'm so glad that she is on. Let me make sure she's here. She's not here yet. Uh-oh. Hopefully she'll be able to find us. But unfortunately, in our community, a lot of people are decimated by the financial impact of high conflict divorce and legal abuse and post judgment. And there she is. Hi, Adrienne. I see you. Let me just invite bankrupt because of the costs. Often they lose their job because of, the money and the time that's taken off from having to go to court. There you are, Adrienne.
I am. Yeah, sorry,
Yeah,
technical glitches.
that's okay. That's okay. Yeah. So I was saying that, I have not interviewed a bankruptcy attorney before, but I think it's so important. And I'm thrilled that you agreed to do this because unfortunately, a lot of our clients end up in poverty or do have to declare bankruptcy because of being involved in these protracted litigation where their ex is trying to wear them down and bleed them dry financially. And it happens. And sometimes they go homeless for a while and they lose their businesses and they lose their jobs. And so I thought that especially having you here to talk about things that people can do to hopefully avoid that or protect themselves, like what to know sooner rather than later, would be such an excellent topic. And we have referred someone we know and really adore to you who gave you wonderful commentary on how helpful you were to her. So
Good.
I knew that you'd be the right person to interview. So before you even formally introduce yourself, can you just say why you think that bankruptcy could be a great start? Because wow, I mean, I think most people think it's the end of everything.
Well, it's funny that we're talking about bankruptcy and divorce because I always joke with my clients that no one ever wishes they had waited longer to pull the trigger on either, right? It's always a painful decision, but it's always a necessary decision. And sometimes it's just kind of like ripping off the Band-Aid. And it's a very freeing feeling once you realize that you've done that. And I think the key is really having a solid professional to guide you through the process to sort of prepare you for what it looks like. And like most things, if you understand it, it becomes a lot less scary.
Yeah, exactly. I always think about how when we talk to people, like clients for the first time, we say, our goal is to keep you as calm as possible, not by saying calm down, but to help you be focused and organized. And part of that involves knowing what to expect. When you know it's coming, there's less to be scared of.
Right, exactly. And honestly, the bankruptcy process for both businesses and individuals, because I handle both, it's not ever as bad as people think it's going to be.
Really?
Um, yeah, I think the media has done a really good job. I think lenders and credit card companies have done a really good job at making it sound like a terrible, terrible option. And I think there's a solid reason for that. Despite the default rate on credit cards, when's the last time you saw a supplier of credit cards file for bankruptcy?
Yeah, good point.
Yeah,
Great.
exactly. Because they're making their money off of people. And that's the other thing I really try to convey to my clients. Get rid of the guilt. The credit card company is the one who decided to give you access to credit well beyond what they damn well knew you could actually reasonably pay. I mean, I myself, look, I'm a professional. I make a decent income. I have access to so much credit that if I were to use it, I would be in bankruptcy. And, when you have access to it and a need arises, right? Like you're financing your bankruptcy, or a loved one becomes ill, a pet becomes ill, you yourself become unemployed, and you have access to that money, of course you're going to use it, right?
Yeah.
And so then you use it for a very legitimate purpose, and all of a sudden you realize, shit, I can't pay this back. And I find that most people really do go into it thinking that they will be able to pay it back, and that mentality carries forward, right? So I'll have someone come to me with, some staggering amount of debt, and they will have tried, in many cases, to enter into payment agreements or, the debt restructuring companies, which are, listen, there are one or two that are decent organizations, but there are a lot of scams. And I've had clients tell me that they paid all this money in and they didn't see any significant reduction in their credit card debt. So they're well-intentioned and they're trying to make it work going all along. And then finally, they just hit the wall. So a lot of times, yes, I am the last resort call. I mean, I guess, unfortunately, no one ever really looks forward to calling
No,
me. Um,
me neither.
but but I do find that after I explain the process and the benefits, I mean, the tremendous benefits, because if you qualify for Chapter 7, and we can talk about what that looks like, then you're talking about wiping out virtually all of your debts, all of your financial obligations. Not all, but in many cases all, and it really depends on what those debts are. And if you think it would be helpful, I'm happy to talk about what is typically dischargeable and what is not, and what are some things that may or may not be dischargeable.
Okay, well, before we even start talking, let you formally introduce yourself.
Thank you. So my name is Adrienne Woods. I've been a bankruptcy attorney for 20 years. I've done everything from clerking in the Southern District Bankruptcy Court for New York to working at large law firms to I was a bankruptcy legal analyst at Bloomberg. I had my own practice for a decade after that. And then recently, I started the bankruptcy group at Weinberg, Zara, Malkin Price. And we are now a bankruptcy group of two and growing because it's a busy area right now.
Yeah, I can imagine. All right. So when we first talked, you said there was a lot of dumb stuff that people do.
Yes.
Can you talk about
And
that? Like when do they do it? And what is it? What do they do? And why do they do it?
well, I think it really all derives from the fact that, look, most people take on debt and have a legitimate belief that they will be able to repay it and a desire to repay it. So, I mean, I hate to demean people and say the word dumb, right? And I use it in the term of lack of knowledge, right? Because they don't know. So, for instance, you know, someone might clean out their retirement account, and I've had this happen on multiple occasions, to pay off credit card debts. Well, credit card debts are dischargeable in bankruptcy, and retirement accounts are what we call exempt assets,
Talk about
meaning that
what does dischargeable mean specifically?
dischargeable means that when you go through the bankruptcy process, that debt is eligible to be discharged. And there are nuances to it. Some people can make arguments that it shouldn't be discharged under certain circumstances, but as a general rule, that type of debt is dischargeable and you can get rid of it.
Oh, okay, get rid of it. All right.
Yes.
All right. So sorry, you keep going. So other stuff that people do out of ignorance.
Yes, exactly. And so, if you use an exempt asset, and an exempt asset is an asset that you get to keep after you go through the bankruptcy process. So the bankruptcy code provides for, well, the code provides for two possible sets of exemptions in most cases. You have the federal exemption scheme and you have your state exemption scheme. The states all vary according to what state law provides for under debtor creditor law. Um, for instance, New York has a very generous homestead exemption. You get to keep, depending on the county that you live in, you get to keep anywhere from $60,000 to almost $200,000 worth of the equity in your primary residence.
Wow.
Florida has an unlimited homestead exemption. So if you qualify to file in Florida and you have, say, a $3 million house and you have no mortgage on it, that is yours to keep.
Even
So,
if you're bankrupt.
yep. And as does Texas, by the way. Are you seeing a theme with the states that I'm referencing,
Yes,
by the way?
actually, those are the states where we have many clients: Florida, Texas, New York,
Yep,
California.
yep. And meanwhile, New Jersey has no homestead exemption,
Hmm.
meaning it doesn't matter if you have equity in your home, you don't get to keep that. So that's why bankruptcy planning is so important, and it's important to understand the benefit of which exemptions to use. So for instance, if you're filing in New Jersey and you you don't have access to homestead exemption, you very well probably, if you own your home, you want to go with federal exemptions because they have a small but still meaningful wild card exemption, we call it, that can be used for any purpose to exempt any asset up to a certain dollar amount. So, where was I going with this?
No, we were talking about like
Things
dumb stuff
things
people
people
do or
do.
ignorant stuff,
Yeah.
like because when you, as you're saying this in my head, I'm like, oh, I thought if you're bankrupt, like you just lose everything, especially your home.
No. And actually, a lot of people come to me in order to save their homes from being foreclosed upon. So if you file a bankruptcy prior to a foreclosure sale, and when I say prior to, I mean even the morning that the foreclosure sale is scheduled, you stop that. You stop the
Wow.
foreclosure. Yeah. Now, I mean, look, the flip side of that is you need to have a plan in place as to what you're going to do because the automatic stay kicks in. The automatic stay is an automatic stop to any effort to collect against you. But a secured lender, i.e., a mortgage holder on your home, right? They can seek relief from the automatic stay unless you are making your post-petition payments on your mortgage going forward. And at some point, you have to decide, are you going to keep this property or not? And if you are, you're going to have to cure all of the arrears. But, it gives you that breathing spell to make that decision, to see if, maybe you can borrow money from friends or family, or maybe you have enough equity in that home that you can that it's worthwhile for you to keep it, and maybe it's not, but it's never a good idea to make a decision in a rush, and that's
Mhm.
why I urge people to have the conversation early. Even if, like, the client that you had referred to me, we had a discussion about her situation, and we determined that she didn't really need to do anything immediately. There was no imminent threat,
Yeah.
right? And and sometimes, it makes sense to wait. And but it should be a decision, not a knee-jerk reaction.
Right, like an informed decision. And I think that
Correct.
too, just knowing that, because I think, especially with a lot of our clients, there's this looming thought, I'm going to have to declare bankruptcy because I'm swimming in debt and I'm so scared to do it, and they're just stuck in this limbo because they're
Hmm.
terrified. And so you're saying basically have the conversation because what you're thinking might not be true at all.
Correct. And, I've had people ask me questions from, I had one older lady ask me if they were going to take her pet. I mean, I know, how heartbreaking is that? People really think that the process is so much worse than it is. And honestly, it's not that terrible.
Wow. All right. What is, now we're going to get a little technical. What is subchapter 5 and 2 criteria for a plan to go through?
So, okay, subchapter 5 is relatively new. It's a creature of a 2019 amendment to the Bankruptcy Code. And it's essentially a small business bankruptcy, but it goes a little bit beyond that. So, um, and there have actually been some very recent changes, and by recent I mean over the past 2 weeks, to Subchapter 5, which we hope are going to revert back to what they were. So, Subchapter 5 allows a small business or an individual whose debts are primarily business debts to go through sort of an abbreviated, streamlined process of Chapter 11, which is a traditional business reorganization or a traditional, we call it rich person bankruptcy, like Mike Tyson filed for Chapter 11, right?
Mhm.
Um, but it's expensive. And it's expensive for multiple reasons. First of all, you have to pay quarterly fees to the Office of the United States Trustee that are based on how much money your estate spends over the course of that quarter. Um, there is a presumption that the U.S. trustee will at least try to appoint a creditors committee, and the debtor is typically responsible for all of the administrative expenses of the creditors committee. And by that, I mean their attorneys, their financial advisors, if they manage to put a CRO in place. So all of these things add up. Additionally, it's you have your own professionals that you have to retain for a longer period of time because the process is not as streamlined. There are a lot of expenses in a traditional 11 that we managed to wipe out in a subchapter 5. But there are a few provisions that are actually, to me, even more helpful than the cost reduction. So, unlike a traditional Chapter 11, you don't need a consenting class of creditors to confirm a plan. As you alluded to a few moments ago, you have to meet roughly two criteria. You have to give creditors at least what they would get if you were liquidating under a Chapter 7 bankruptcy, and you have to contribute the all of your net disposable income into the plan over a 3-year period of time, which can be extended to 5 years if you can't give people what they would get in a Chapter 7 during that 3-year period. So, what does that look like? Well, net disposable income is kind of what it sounds like. You're running a business, right? You get to continue running your business. You get to continue paying your employees. You continue buying from your vendors. You continue dealing with clients. You pay yourself a reasonable salary. And then whatever's left over is your net disposable income. I actually confirmed a plan last year where creditors were paid 1.5% on the dollar. And that was a confirmed plan because it was a service company. And if you liquidate a service company, it was specifically a security guard company, you know, the guys who guard construction sites.
Mhm.
So this was one of my pro bono projects, actually. This gentleman had come here from Guyana and didn't understand the wage and hour laws. And they're pretty strict. It's strict liability. It doesn't matter if you just didn't know, and ended up with a significant debt against his company. His company didn't make a lot of money, which is why I took the case pro bono, but they they made enough to employ him and two other people, and they performed a service, and it was a viable business. So we want to keep those people employed, right? We don't want this guy out on the street. We don't want to have him have to let two employees go who are feeding their families on this job. So for that reason, we have bankruptcy, right? It's a gift, really.
Wow.
So we were able to, because if you liquidate a security guard company, what are the assets? There are no assets,
Mhm.
right? You've got a computer that you do scheduling from, full stop.
Yeah.
And so we had to basically confirm a plan that would provide creditors with, I think we had like $3,000 in terms of what our obligations were. Meanwhile, the debt that he had was about $60,000, which, to you or I may not sound like very much, but to this gentleman, it was a significant amount of money and it would have put him out of business.
Yeah.
So it enabled him to continue operating. And I heard from him a few months ago. I actually get follow-up calls from some of my clients sometimes, which is nice. And he's gotten several more projects, employed several more people, and he's doing well.
Wow.
So
That's great.
that's why we do it.
Yeah. I mean, I just think about again that theme of starting over, like it's a new
Yeah.
beginning, and how our clients too with the whole divorce and being decimated financially, that you can kind of pick back up from it
Hmm.
and continue.
I mean,
All
look, I
right.
myself am divorced. I get it.
Yeah. Yeah.
It's actually a
So
great thing.
so let's continue about people that are not dealing with it. Like, what are some, we talked a little bit about payment plans, but often people have a thing where they don't open their mail. It's almost like they're in
Mhm.
denial. How can it harm you? See, one of the things that we believe is that education is empowerment, and that ignorance is way more expensive.
It is.
So when you don't open your mail, that can be harmful. What else? What are some other ways that people are not dealing with this issue that they really need to deal with? Just like in divorce, there's things that they should be dealing with that they're afraid to deal with.
Right. Exactly. So, I mean, you pointed to the not opening your mail. Well, if you're avoiding getting sued and you're essentially dodging service of process, eventually they will serve you. And if you just don't open it, then you're going to get a judgment against you. Once they have a judgment against you, they can garnish your wages, they can seize your bank accounts, they can do all this other stuff. Whereas if you open your mail and you say, oh my God, I'm being sued for XYZ, I can't afford to pay that, and you call a professional, i.e., a bankruptcy attorney, and you have the conversation, you determine whether or not you qualify for bankruptcy, under what chapter, whether or not it would benefit you, you can immediately stop the collection activity and you
Yeah.
can protect assets that you can protect in a bankruptcy. So, obviously that's, I think, the very big one, just addressing the problem and really facing it head on. Um, And that's the primary avoidance thing. Also, you can tell creditors that they're not allowed to call you. You can
Mhm.
say that, and they're required legally to not call you. But they're pretty much almost always going to turn around and file a complaint as soon as you say that. So, avoidance, I think, is the biggest issue there.
Yeah. Yeah. All right. So in our part one, which is now just posted on my feed because I didn't want to lose it, we talked about how bankruptcy is a fresh start, the dumb or ignorant stuff people do to kind of avoid the, dealing with it. And then you just talked a bit about subchapter 5, which doesn't relate directly, I think, to a lot of our people because it's more business, but still a lot of our community is dealing with businesses and feel like everything's going to be lost. And you gave a great example of this particular man who could still continue with his life and actually continue to thrive with his business even while going through this. And then we talked a bit about how people avoid dealing with scary issues like this and the parallels between not, denial in bankruptcy as well as divorce. And I wanted to talk, and then we started talking a little bit about timing and really trying to deal with things sooner rather than later. What's one of your biggest frustrations as a bankruptcy attorney?
Um, well, it's there are a few. I mean, the timing thing is definitely one that's very frustrating because of the fact that, you know, it's just like, if you had just come to me before you had done this, right? If you had
Mm-hmm.
come to me before you, I don't know, um, transferred your assets to your spouse or your brother and thought that that was going to be a way to avoid the obligation, or before you spent money that you didn't need to spend, or went to a debt consolidation company that essentially scammed you. And again, I'll say it, not all scams, but there are a lot of them that are. Um, and I think those are probably my biggest frustrations. People who try to solve a problem themselves that is just far too complicated for most people to solve because they don't understand what their rights and obligations are.
Yeah, yeah, yeah. Okay, so speaking of things that most people don't understand, a lot of people that we coach do know this term. What is the cost benefit analysis?
Well, I mean, as related to filing a bankruptcy, you mean?
Mm-hmm.
Yeah, so I mean, generally speaking, if you're going to be filing a bankruptcy, you have to understand that there are certain costs associated with it. And those costs include both, the financial costs as well as the non-financial costs. Like it is going to hurt your credit rating. Now, the flip side of that is, invariably, if you're looking at filing for bankruptcy, your credit is not exactly stellar. But I have had people come to me where they have very, very good credit and it was really sort of a difficult decision for them to make. So, it's what is the benefit? How much debt am I going to be able to discharge, right? How many obligations will I be able to free myself of? What assets am I going to get to keep and what am I not going to get to keep? Am I going to lose something that's incredibly meaningful to me? And I do think when you're looking at a cost benefit analysis, it does go beyond the purely financial, right? We have things are things, but sometimes we have sentimental attachments to things. And if you can't bear to part with XYZ and you know you're going to lose it, then that may skew the equation for you.
Yeah. What should people know about family assets and things in a trust regarding bankruptcy?
Yeah, that's a good question. So I've had numerous people come to me over the years with trusts, and you know, I'm not a trust and estates lawyer. I mean, look, technically, as a lawyer, I can practice in pretty much any area of law that I want, but I really choose to stay in my lane because I think that people who try to do everything generally do everything poorly. Um,
Mhm.
but what I can say as a generalization is that not all trusts are bankruptcy remote, meaning that you can protect those assets in the case of a bankruptcy. Putting something into something called a trust is not going to necessarily protect it. The form of the trust matters. Um, Whether or not it has what we call a spendthrift provision matters. It's got to be a valid spendthrift provision, which essentially means that the beneficiaries of the trust have no right to declare a distribution or take a distribution themselves. They can request it, but it may or may not be granted. But again, I always send people to a trust and estates lawyer that I know and like and trust, haha, um, or if they're sophisticated parties and they have trust and estates counsel that hopefully has worked with them to create the trust, because and I'll tell you one point of frustration for me, and I think a lot of other lawyers, is people who want to play lawyer on LegalZoom, and then they think they did it right, and then you have to sort of unravel their mess because they didn't want to spend the money.
Mhm.
But I find that in some areas of life, you can't afford to be cheap.
Yeah.
Um, the cheapest option is not always the best option. But yeah, no, I mean, I always have people go to a trust and estates lawyer and confirm that this is actually bankruptcy remote before we put them in, because you don't have an automatic right to dismiss your bankruptcy case. With the exception of Chapter 13, you do have an automatic right to dismiss a Chapter 13 case.
Okay. Yeah. So this is clearly something to take seriously.
Yes, and
Uh,
once a Chapter 7 trustee sees the word trust, they think money. So they're going to investigate that, until they are absolute, which is, they have to, it's their fiduciary duty.
yeah.
But they're going to investigate that until they are 100% sure that they can or cannot reach those assets. So, you really have to be sure. It's not something to guess at.
Yeah. Yeah. So never assume.
No.
Okay. And then I love that you encourage people to do certain things themselves, not that, but there was something that you were talking about that you tell people and they can save thousands of dollars. What situations would you encourage people to actually do parts of it themselves?
I mean, look, if you truly have no assets to protect, and you can't afford to get good counsel, then there's generally no harm in filing your petition as a pro se. It costs you $338 as a filing fee. There are pro se offices that are available to assist people who are filing pro se. It's generally a limited representation, right? Like you meet with someone who is a lawyer, and they will give you advice based on that conversation then and there. And generally speaking, the representation ends when you walk out the door. But if you're really just, you have no assets to protect, you have debts that you can't afford to pay, you just want to get your fresh start and move on, then that's, it's not a terrible idea to try to do it that way. The only problems that I find tend to come up in those circumstances is people may not realize the impact on other people that they might have given money to. So for
Mm,
instance, if I decided that I was going to give, $10,000 to mom, within the 90 days before I file for bankruptcy, and then I file for bankruptcy, mom's getting sued. So,
really?
there are provisions in the, yes, there are provisions in the bankruptcy code which understandably provide that certain monies that are paid to insiders and outsiders, there are different look back periods, can be clawed back into the bankruptcy estate for the benefit of creditors. And the reason for this is obvious, right?
Yeah.
Because, if you're filing for bankruptcy, why wouldn't you, if you could, transfer all of your assets to the kids and, right?
Yeah.
And so it sort of tries to head off that bad behavior. But a lot of people do it quite innocently and don't realize it. Um, the other, if we're talking about mistakes in terms of that, trying to hide things, um, bankruptcy is really very much about transparency. And it's an excellent system for helping the honest and unfortunate debtor to get ahead, right? But people who try, my spidey senses always tingle when people call me with questions like, well, what if I did this? It's like,
Oh,
no, 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 no. Like, no. And if you want to do that, you really need to find a different lawyer, because I'm not losing my license for you.
right. Right. Yeah. Well, Adrienne, thank you so much. Is there anything that we forgot? I mean, I know this is a huge topic, but
Yeah.
I don't know if there's anything that you want to leave people with of like, make sure you do or don't do this, and
Yes.
then tell people how to find you.
So I would say the biggest thing is if you see on the horizon that you're you're likely not going to be able to continue, right? That you're not going to be able to meet your financial obligations, have a conversation sooner rather than later. I know I myself, and I find that most other reputable professionals will give free consultations so that they can determine whether or not bankruptcy is right for you. Anybody who wants a significant amount of money just to sit down and have an hour conversation with you, I would say don't, because I mean, look, we have to make a living too, but I think I personally don't find it morally appropriate to take money from people that, you know, A, don't really have it, and B, I can't help, right?
Mm.
Um, and but have the conversation early. Have a real in-depth conversation with somebody who's going to ask you, okay, what is your whole financial picture? What are your goals? What are you trying to protect and preserve? What are you okay with losing? And really understand the process so that when you do go forward, you're comfortable doing it and you've got a rapport with the person that you're going to be working with. Bankruptcy is an incredibly intimate process. I
Mhm.
mean, I'm asking people about their marital situation. I'm asking people about their relationship with their adult children who are living in their homes. I'm asking about potential mental issues. It goes beyond just finances. And you really need to have a good relationship with the person that you're having that conversation with because you have to be honest with them.
Yep. And again, so many parallels with divorce here,
Yeah.
right? All
Oh,
the professors you
totally.
work with, you're basically emotionally undressing before all kinds of people, and
Yeah,
you need to be able to feel comfortable or at least
definitely.
okay. Yeah.
Hopefully you love them. I've had somebody tell me that I make bankruptcy fun, so that was high praise.
All right. So how can people find you? And where can you, like, who can you serve specifically?
So I work in the southern and eastern districts of New York, which is generally speaking, Manhattan, Brooklyn, the New York metropolitan area. But I also do assist people on occasion outside of that area if it's somewhere where it makes sense for me to get involved.
Mhm.
So, if I've ProHawk means you're allowed to appear on a specific matter into Delaware. I'm going to be doing a case for someone in Kansas because it's, not a typical, it's a little more complicated. So it really depends. But in general, as a general rule, I'm barred in the southern and eastern districts of New York. And people can reach me by telephone, 917-447-4321. People can reach me by email, awoods@wzmplaw.com. I don't know, is there a way to put it in the chat? I'm
We can
not sure.
we can try. I can try. But you know what? I'm going to
Um,
tag your account so they'll
yeah,
they'll be connected to you to your information too.
excellent. Yeah, and thank you so much for having me.
No, my pleasure. Thank you so much for doing this. And
My
I'll see you
pleasure. Have a
soon.
great, take care. Bye.
Bye.